Hey y'all, and welcome. Thank you so much for joining me today. My name is Trish, and I will be doing a webinar on estate and legacy planning. Again, I'm Trish Butcher. I'm the owner and attorney with Butcher Health Law here in Athens, Georgia, and I really am looking forward to getting the opportunity to help educate the Athens community and the Georgia community on how to protect your loved ones and family, how to keep them out of court and conflict, and how to protect them if anything was to happen to you. So as a thank you, I know that everybody has very busy days. I know that it takes a lot to take 30 minutes out of your day to listen to something like this. So as a thank you, I'd like to offer a complimentary virtual one-on-one meeting with all of y'all to talk a little bit more about you and your family and your situation and kind of where you are now and where you would be with estate planning, and to help you understand that a little bit better. So hang with me towards the end of this webinar and I'll tell you a little bit more about that in a minute. So question number one, we're going to go ahead and hop right into this. Oh, and if you do have a question or a comment, please be sure to throw that in the chat box and we will get back to you as soon as possible. When you ask the question, make sure to include your email address so that we can email you directly with an answer. If you'd like to schedule a consultation, please feel free to do the same thing and throw that in the chat box. So question number one, do you currently have an estate plan? If not, you're not alone. It's estimated that around 69% of Americans do not have an estate plan, which is a really surprising number to me, but at the same time, I understand that a lot of people don't really know that much about estate planning. So that's kind of what my goal is to kind of make this number a little smaller, because I think that it's so important, and I think a lot of us don't realize how important it is. So if you do not have a plan, why not? Are you too busy? Are you too young? Maybe you think you don't have enough money. I know that I hear that back from a lot of clients. Well, I mean, we don't have that many assets yet. And I think that a lot of my clients are always surprised that when I break it down for them, they realize that they do have a lot of assets. So again, these are all very common reasons why a lot of people don't have estate planning, and we'll make sure to go over all of this in the webinar today. So if you do have estate planning, what are you hoping to learn here today? Is it to get a better understanding? Are you wondering if the will that you completed online, is that okay? Or maybe you think your plan's outdated. A lot of people, think that they can create a will or some type of estate plan, get the documents, sign them, throw them in a drawer, and just kind of forget about them and think that they're totally safe. Well, here at Butcher Health Law, we want to help people understand that that's not necessarily the case, because in a lot of cases, situations change, the law may change. So oftentimes you might need to look back at that plan. So again, we're going to go over all of this today. You are in the right place if you have someone or something that you care about and want to protect. Or maybe you did a fill-in-the-blank will and you're not sure if it will work. Or maybe you're nervous about the cost of estate planning. I know that people kind of make attorneys and dollar signs a little synonymous. Also, maybe you just don't even know where to start. We've all been there. New things are scary, especially topics that are as morbid as estate planning. So you're in the right place. The reality is that estate planning is not about you, it's not about me, it's not about us. It's about our family and our loved one, and it's protecting them. It's making sure that they can grieve in peace and not have to worry about all of this erroneous, extra complicated stuff, family conflict, anything like that. We want to make it as easy for them as possible, because the fact of the matter is, if we're gone, they're grieving. And your loved ones at this point will know whether you lived up to your promise of I took care of it. And we, on a day-to-day basis, we do everything we can to protect our families. And a lot of people don't realize that that's what estate planning is. It's protecting them after we're gone. So that is the hard reality that we have to face. And I know that all of y'all have people that you love and want to protect. So that's what estate planning is. So what will you learn today? Today we're going to look at the Smith family. It's a hypothetical family. I'm going to go ahead and warn you, trigger warning, they are going to have some rough times ahead. but we're going to look at them from 3 different perspectives. We're going to look at their situation as if they had no estate planning, if they had basic estate planning, or if they had personalized and tailored to them estate planning. So we're going to kind of look at the what ifs from these 3 different perspectives to get a better understanding of what exactly estate planning can do to protect your family. In the meantime, I want to tell you a little bit more about me and my family. So as I mentioned, my name is Trish. I am born and raised in Athens, Georgia. So this is my hometown. I am a native Athenian. I have 2 furries. I have a dog and a cat, Whiskey and Woodford. And then I'm lucky enough that most of my family actually still also lives here as well. My brother is the only one that kind of escaped to Denver. But we're all here, and this is really my hometown. I have 1 son. He's the little bald baby right there on the screen. He's a bit of a savage. He's commonly referred to as a lot. So balancing work and motherhood has been definitely a learning experience for me. So my husband Andy has been amazing, and my son Max, and you can see us there in the upper corner at a Georgia game. We're huge, avid Georgia fans, even though my husband graduated from Georgia Tech, but we won't talk about that. So I went to UGA for undergraduate and graduated in 2010. I kind of continued my Baxter Street journey by doing that. I went to Clark Middle and Clark Central, and then went on to UGA. So Baxter Street has played a rather large role in my life. I was actually in a sorority as well, and my sorority was also located on Baxter Street. So I spent a lot of time on Baxter Street. After UGA, I went to Emory Law School, went straight through, and I lived in Atlanta for about 6 years. I did take a short break from Athens, and I went to Emory, and I started working for the Medical Association of Georgia when I was in the summer after my 1L year. So I worked for MAG for about 5 years, because after graduating from Emory, I went on to become their legal counsel. So I lived in Atlanta for about 6 years total. And after that, we kind of decided that we needed a break from Atlanta, and that Atlanta wasn't really where we were looking to raise our family. So we decided to move back to Athens. And I actually opened up an all-women's gym for a while. That was successful and great, but my priorities kind of shifted as I had my son. But health and wellness is something that's always been very near and dear to my heart, as well as protecting the medical and healthcare professionals in their field and working with them. So in 2019, I had my son, Max. It's been a huge learning curve, and we're so blessed to have him, but he really is a lot. So that's really when I started kind of thinking about all of this and wanting to become more of a family advocate. So my why begins and ends with my son and my family, of course. I really didn't start thinking a lot about estate planning until I had my son, and kind of looking around, trying to figure out, how we could protect him and what we needed to do. And, do we do wills? Do we do guardians? These are questions I think a lot of young families have, but, maybe they're just intimidated by the process, or intimidated by that typical ideal of the attorney. So I started looking around, and y'all, I was less than impressed. I was very unimpressed by what was being offered. I felt like even if you went to an attorney and paid the big bucks, it was still basically that same kind of fill in the blank will, name your one guardian. I'm like, is that really enough to protect my son if anything was to happen to me and Andy? So that was kind of my first, kind of trigger as I started to look more into it. Actually go back a couple years though. My grandmother passed away in 2010, so my last year of college. And my dad was an only child. She was remarried. He had 2 children from a previous marriage, and they had a very complicated estate. He was a physician. She was a real estate investor. So they had a large, complicated estate. My guess would be that they had probably spent over $25,000 in estate planning. So you'd think, wow, they spent the big bucks, they went above and beyond. Like, obviously, they were prepared, and my family had it very easy after they passed away. Well, unfortunately, that was not the case. Um, his children from the previous marriage ended up suing the estate four times many times over the course of 4 years, sorry. And it was a disaster. It dragged out, it dragged on. And what a lot of people don't realize is that, yes, this can still happen even if you have estate planning in place. It doesn't necessarily prevent against this, especially if it's not personalized and tailored estate planning. So I was very surprised by that. Moving beyond that, my dad had a will drawn up by a very well-known large law firm here in Athens. And when I was asking him questions about it, as I was going through my master course with New Law Business Model, I'm a certified personal family lawyer and a family business lawyer. And I learned so much in this process. And so I was kind of quizzing my dad about, what he had in place. And he was telling me, and I was kind of blown away because I realized that what he had in place was basically worthless. So he probably paid around $1,500 for this will that literally did nothing that the law would not already do. He left it, his estate, to me, my brother, and my sister. The three of us split evenly, which is fine, but that's what the law would do anyhow. So it really didn't do anything for him. They didn't provide him any of the extra documents like healthcare power of attorneys or advanced wills or anything like that. And we'll go over more of that in a little bit later on in the presentation. But I was just kind of blown away that they actually charged him for something that did nothing. So I really started getting this idea in my mind that maybe what I wanted to focus on was this estate planning. Maybe I wanted to create a better alternative for families. I wanted to recreate the wheel. I wanted to help the Athens community understand that, number one, you don't need to have millions of dollars to need estate planning. That is a myth. And number two, a will, a fill-in-the-blank will, doesn't necessarily do anything for your family that the law wouldn't have already done. So I really wanted to become a family advocate. I wanted to become a trusted advisor. I wanted to become somebody that people could turn to and actually talk about and learn about estate planning and learn why these things are so important and what would best fit for their family. I also really wanted to create a law firm that also focused on helping our medical community, our medical heroes, our healthcare heroes, and really helping them. My background is health law. So I wanted to give that service as well, and asset protection, everything like that. So that's kind of my why and why I ended up where I am now. So, from there, let's go ahead and jump into the presentation. What will we learn today? And that is how estate planning will affect your family. So let's go ahead and get started. And we're going to meet the Smith family. They're just your average family. John, Samantha, the mom and dad, John Jr., and then little Allison are their two children. Just your average family, average Georgia family. And so, sorry, glitch. So, babysitter fun time. The dad is going away on a work trip. The mom has a business meeting. She has to go into work and have this meeting, so they call their longtime babysitter. And the kids are excited. This has been their babysitter from day one. They're really excited about having some playtime and, not a care in the world. So, unfortunately, this is when the story is going to get a little sad. Samantha gets a notice on her phone saying the meeting's been postponed. So she decides to go hit the gym. She puts all of her stuff in the locker room. She gets on the treadmill and bam, she has an aneurysm and passes away. We don't like to think about these things happening, but they do happen. And the babysitter, meanwhile, is calling and calling and calling. She doesn't know where the mom is, can't get a hold of her, obviously, because her phone's locked into a locker room. So this is something that could happen to anybody, and we don't like to think about it happening to us, but it could happen to anybody. I've heard so many stories about someone in their 40s or 30s having just such a random heart attack or an aneurysm or something like that. So at this point, the mother's passed away. The babysitter doesn't know what's happened. She's trying to get in contact with her. So what happens next? With no estate planning, the babysitter calls the police because she doesn't know what else to do. The dad's out of town. She can't get a hold of him. He's in a different time zone. She calls the police. The police have no choice but to take the children into protective custody. And until the dad can get home, maybe the dad has a delayed flight. There's no telling how long these kids could actually stay in protective custody. And a lot of people don't understand this. They don't know that if they don't have some type of planning in place for these bizarre, unexpected events, that this could happen to them and their family, and their children could be taken into protective custody with strangers and be so confused and so upset and without their family. So what would happen if you had simple estate planning? Guess what? The same thing would happen. If you just have a will, simple estate planning, the police are going to come. They're going to take your children into protective custody until the dad can get home. This is what I think a lot of people really don't understand. Naming guardians does not protect against this happening a lot of the time, most of the time. So this is really important to understand, is that if you don't have family members that live in the same town as you, which a lot of people don't, your kids will probably end up in protective custody if something happens to you and your spouse. So this is the will scenario. This is the basic estate planning. And what a lot of people don't understand about wills is that they're not the best at protecting you and your family's assets. A lot of people think that estate planning and wills are kind of synonymous. Well, a will does not control all of your assets or protect you from probate. So that's really important to understand. If you have a will, your assets, your estate will still go through that probate process. And any type of joint ownership or beneficiary designations will override your will. So any 401ks, retirement plans, life insurance policies, these will all override your will. It doesn't matter what your will says. If they're a beneficiary designation, it will override. Or if you co-own it with somebody else. So there's really 3 buckets to a will. Jointly owned assets will go to the surviving joint owner, regardless of what the will says. Next, assets with any beneficiary designations will go to the beneficiary, regardless of what your will says. And then anything left in your probate estate after that, so after the jointly owned and the beneficiary designations are kind of taken out, they will pass pursuant to your will, if you have one, or state law if you don't. And these assets are not going to be immediately available to your family or your beneficiaries. They actually still have to go through the probate court process, which is anywhere from 6 months to 12 months. If it's contested, it can take a lot longer. It depends upon how complicated your estate is. And the probate process is going to be overseen by a random judge that you really have no control over how they handle their probate processes. So that's really important to remember when it comes to wills. Wills are also very easy to contest. Let me say it again. Wills are easy to contest. This is what happened with my grandmother and grandfather's estate. His children continuously contested their estate over and over and over again, and drew out the process for 4+ years, costing attorney's fees and Lord knows what else, and just also making the experience a very hard experience for my dad. They also don't necessarily protect all of your assets, as we previously discussed. So result 3, let's look and see what happened if they had more advanced estate planning. So the babysitter has a plan in place. Personalized estate planning covers all of this. She knows to call a temporary or emergency guardian. He comes, he keeps the kids safe and sound until the dad can come back, and then they grieve for the mom together. So this is something that a lot of people don't know to think about, and most attorneys, frankly, do not offer. They don't know to offer that. Permanent guardians are great, they're necessary, but you also need to have those people that can step in case of an emergency, and they can be there, right there, within minutes at a time, to come in and protect your children and keep them out of protected custody. And this is something that personalized and tailored estate planning can help provide for you and your family, this extra peace of mind when it comes to your kids. So, fact, guardianship is equally about what happens in an emergency as it is about who raises your children if you can't. So again, these emergency guardians, these people that can step in immediately upon anything happening, it's so important, and it's just as important as naming a permanent guardian. So now the story goes on. John decides that he needs to create a will or do some type of estate planning, and he actually takes out a life insurance policy. And then he gets in an accident and passes away as well. Again, I told y'all that this family was going to have some really rough times. So now John has passed away, but he has done some estate planning, and he has taken out a life insurance policy. So what happens now? The children move in with the guardians. So he's named guardians, they move in with the guardians, they start that healing process. But what happens to the life insurance money? What happens to the rest of their assets? This is something that can differ greatly, a lot, with different estate plans in place. So this is a very important question. The kids inherit immediately. This is going to be your typical estate planning. The kids inherit immediately upon turning 18. The judge, in the meantime, will appoint any type of financial custodian the judge decides to appoint, and while they're minors. And then when Allison turns 18, they get that money immediately. And I don't know about y'all, but I'm not sure that an 18 and a 20-year-old would know how to manage money very well. So if he had taken out $1 million life insurance policy and they both get a lump sum of, say, after living expenses until Allison turns 18, say they both get $350,000 each. What do we expect an 18 and a 20-year-old to go do? Well, they're going to go buy a new car and maybe go buy a house, and maybe they're not worried about college at this point because they're like, oh, I've got lots of money and we'll be fine. And then all of a sudden, the next thing you know, they're broke. Happens to a lot of people. We hear it all the time when it comes to professional athletes and people that just haven't had the opportunity to learn about financial intelligence. So I don't know about y'all, but it's definitely not something that I would want to happen. And with basic estate planning, this is what would happen. Your kids would inherit immediately upon turning, the youngest turning 18, after the judge gets to appoint a financial custodian. So who does the judge choose as the children's financial conservator? We don't know. There's no telling who the judge will pick because we don't know who the judge is. We don't know what the options are. The judge can literally choose anybody who they think is best. He can choose the guardian. Maybe an aunt and uncle appear all of a sudden, see dollar signs and come into the picture. He could choose them. They are family after all. Or maybe he appoints a court-appointed financial conservator, someone that's kind of a professional financial conservator. The answer is that we really have no idea. And if you want to know who will take care of your children's money until they, hit majority or the age that you want them to hit before they get this money, estate planning is absolutely necessary. When will the children receive their inheritance outright with no protections or guidance? Again, when the youngest turns 18. So when they're minors, there will be a financial conservator. After they're no longer minors, the younger one turns 18, their money just is given to them outright. So at 18. So let's do something better for the Smith family. They've had a lot of trouble over the last few years. They've had a lot of heartbreak. Their family's been through a lot. Let's do something better for these two kids who have lost both their parents. Let's create a living trust for the dad, John. And a trust is basically a will substitute. So it's a revocable living trust. It takes the place of a will. And what this does is it keeps your assets out of court. It totally cuts out the probate process. The trustee gets to immediately distribute any assets. They get to follow the guidelines, and a trust can be very creative, and we can do anything you want with a trust. So a trust is what we often refer to as the better will substitute. So there's 3 buckets again. Your share of jointly owned assets are put directly into your trust. beneficiary designations are updated to be your trust. So therefore, if you have a life insurance policy or retirement account, the trust now becomes your beneficiary designation. And then all of these assets are going to be immediately available for your loved ones, and there's no judge required. No one you don't know making decisions for your family. You don't have to worry about the state law making the decisions for your family. As long as everything's, of course, within state laws and legal. But the trust gets to decide everything. So everything, all of your wishes are put into this trust, and the trustee handles it according to your wishes. So this is what makes a revocable living trust so much more important, so much more helpful than a will. And a lot of people hear the word trust and they just immediately think of like, oh, those trust fund kids. You know, the kids that grandparents leave them trusts for, you know, hundreds of thousands, millions of dollars. And yes, those people still exist, but trusts are so much more than these trust fund kids. It's so much more than that. These are revocable living trusts. While you are living, it's all still your money. You're the grantor, the trustee, and the beneficiary. You play all three roles. It's all still your money. There's nothing scary about it. But what it does is it puts it into this big bucket and makes it so easy for the trustee to manage it and distribute it as you would want if you were still there. So result two, the kids receive inheritance in a trust. So John didn't just create estate planning, John created personalized and tailored estate planning. And he put all of his assets into this big bucket that is his revocable living trust. And when he passed away, he was able to designate how his children would get their money. They don't just get it at 18 and 20. They get it later in life when he chooses, the number he chooses and the method he chooses. Because what a lot of people don't realize is that your kids don't have to get this money outright. Which opens them up to divorce, creditors, lawsuits, anything like that. You know, once you inherit money and it's in your bank account, it's your money. So anybody can come after it. And if your kids get a divorce down the road, half of it's probably going to go to that spouse. Or if your kid's in a professional position where they face lawsuit, you know, if the insurance gets busted, then they can come after these assets. So there are other ways to protect these assets even after you're gone. We can create what we call a lifetime asset protection trust. And these would protect the money for your child's lifetime and beyond, really. And protect it from divorces and lawsuits and creditors. So you can get so creative with trust, and this is what we really love about it. It's so much more personalized to what your desires are for your family and how you would want your kids to be protected. So, you know, now here are Allison and John Jr. They've gone to college. They have families of their own. They have this protected trust put aside to help them succeed, to help them start businesses or, you know, buy their first home. And they get to remember their mom and dad with love, knowing that they protected them and they took these extra steps. So what are some other considerations of estate planning? One of the things we didn't really get to talk about with the Smith family is, what about incapacitation? What if something happens to you where you don't pass away, or you don't pass away immediately, and you're in the hospital, but you're incapacitated? You can't make these decisions that you would typically make for yourself. These are the other documents that I think I mentioned earlier with my dad's estate that were not included. And these are documents that are just as important as your will, as your trust, as the rest of your estate plan. These are the documents that say, what if I'm incapacitated? And you get to choose what would happen if you are. And this is so important. So number one is the power of attorney. A lot of us have heard of power of attorneys. Maybe we don't know exactly what it is, but a power of attorney is when you're basically giving someone else the ability to make all of these decisions for you. They're going to basically make sure your life is still functioning, still running. They're going to pay your mortgage or your rent. They're going to pay your bills, make sure everything is handled. They're going to pay your car payment. You know, they're kind of going to take over like the financial side of your life that does have to keep running, because the mortgage company doesn't know that you're in the hospital. The bank, you know, doesn't know that you're still in the hospital. The credit card company doesn't know that. So these are things that a lot of people don't think about. And with personalized estate planning, one of the things we do is we make sure that we actually get you financially organized. We get all of your assets into one place and listed so that this person or the trustee, if you've passed away, know what assets you actually have. Because if you don't do this, how do they know? How do they know that you have 3 separate bank accounts or that you have 2 different retirement accounts? So again, power of attorney, very important. If you're incapacitated, they're what's going to make sure that your life continues moving on. The next is the healthcare power of attorney. And this is who's going to make those medical decisions for you. Who gets to decide what surgeries you have? Who gets to decide what interventions are done? Who gets to look over your medical records? So this is the healthcare power of attorney. This is where you choose the people that you really trust to make your healthcare decisions for you, whether it's your mom or your sister or your husband or spouse or whoever it is. And of course, typically with a healthcare power of attorney and power of attorney, your spouse would be your first choice. But what if your spouse isn't there? We get to name successors for them. We get to name someone else who could step in and do this if your spouse is not available to do it, or if you're single. Really extra kind of important if you're single or divorced or anything like that. The last document that is really necessary if you're incapacitated is this Advanced Healthcare Directive or Living Will. This is, again, something a lot of us don't like to necessarily think about, but I remember when I was young, I remember hearing about the Terry Schiavo case. And of course, I didn't really understand what was going on at the time, but I do now. The Terry Schiavo unfortunately went into a permanent vegetative state. Several doctors concluded that she would not be able to recover from this vegetative state. The only thing keeping her alive at that point were machines. And her husband wanted to turn off the machines and let her pass naturally, whereas her parents wanted to keep her on the machines, probably hoping for some miracle or something like that, even though the doctors had assured them on multiple occasions that she was not going to be able to come out of this vegetative state. So if you are someone who would not like to be kept on machines, who want to make that decision for yourself if that was to ever happen, this is what an Advanced Healthcare Directive can do. And it's going to say, let me die naturally. If multiple doctors have said that I am not going to come out of this vegetative state, let me pass naturally. Unhook me from the machines and let me pass. Another thing that would do would also be kind of a do not resuscitate, a DNR. So if you have a terminal illness, you're at the end stage of that terminal illness and you have a heart attack, it would be a do not resuscitate. So it would be, don't use the paddles and bring me back to life. So this is basically allowing you to decide what would happen when obviously you're not capable of it. Also, it has provisions for if you're pregnant. It has provisions for what you want to do with your organs, and even asking, whether you want to be buried or cremated. So again, just decisions that you might want to make. This is going to help you. These are all going to allow you to make them when you're not able to, but you are still technically alive. So, looking at the Smith family situation and the other considerations, let's go over the lessons that we've kind of learned. Our children are our most important assets. So, like I said in the beginning, a lot of people think they don't need estate planning because they don't have enough assets. Oftentimes, they're not thinking about the fact that they have houses or retirement accounts or life insurance. These are all assets. But sometimes we look at our bank account and, maybe we only have $500 in it. And we're like, I don't really have enough assets to need estate planning. Well, beyond your house and beyond retirement accounts and everything like that, if you have children, you have assets. Because at the end of the day, our children are our most important assets. If we lost everything tomorrow and we still had our children, we're still okay. So put aside thinking of assets only on a monetary basis and consider your children who you've done everything to protect up until this point. And you haven't really thought about it because we don't like to think about morbid issues like us dying unexpectedly. But again, we do all pass away eventually. And so we do need to provide for this and make sure that our children and our family are still protected. So guardianship is so, so, so important. Permanent guardianship's important. You want your kids to end up with who you want them to end up, who share certain values or who live in the same area or who can financially support your children. But but also it's those emergency guardians. It's who can step in case of emergency, who can protect your children if something happens immediately, who can be there immediately and keep your children out of protective services, and also make any decisions for them if they need medical care. That's another consideration. So all of these things are super important. If you have children, you do have assets, and you do need to protect them with estate planning. The only other person that can make your decisions for you is a probate judge. Basically, think of the probate process as basically getting your signatures that you didn't currently, that you can't give. Obviously, you've passed away. So the probate process is in lieu of those signatures. So changing bank accounts over, changing car titles over, everything like that is going to have to go through the probate process if you don't have a revocable living trust in place. And this process isn't cheap. There's court fees, which aren't awful in Georgia. However, attorney's fees get very expensive within the probate process. And it's always kind of a given that you will need an attorney helping you through the probate process. And if things get complicated, that bill just goes higher and higher and higher. So it can be a very expensive process. And personally, I want to make my own decisions. I don't want a judge to make the decisions for me. So, as I mentioned, a review of all of your assets must be a part of your estate planning conversation. Y'all, this is so important. Nobody knows what you have except you, unless you list it all out and get financially organized. And this is something that a financial planner can help you do, or we can help you do it. With personalized estate planning, we actually walk our clients through becoming very financially organized and getting all of their assets together so that if anything was to happen to them, it's all going to be in your estate planning binder. And they can easily access what they need to do, what accounts they need to transfer over, and everything like that. It's not an exaggeration when I say that this is something that's often overlooked, because in Georgia alone, there is over $1 billion in the Georgia Unclaimed Properties Department. This is insane, y'all. There's $1 billion worth of property that people have not claimed because maybe they just don't even know it exists. So this is something that we definitely want to protect you against. And just drafting a basic will does not prevent against this at all, because again, people have to know it's there in order to get it. So again, I think the number one myth that we've addressed throughout this is that having a will alone will protect your family from the lengthy and costly probate process. And that is in fact false. So it's a fill-in-the-blank will online, while it can at least give some guidance to a judge is still going to have to go through the probate process. It's still going to, your family is still going to have to go through this probate process that is lengthy, expensive, and full of opportunity for people to contest. So how is BHL, how is Butcher helpful? How are we different from other attorneys? I mentioned earlier that one of the reasons I wanted to start this law firm was to really make a difference and to become more of a trusted advisor versus that one-off attorney. I wanted to be somebody that somebody could talk to and not worry about hourly billing. So that is the first one. The traditional experience is hourly fees, and how much is this attorney going to charge me for giving a call to ask a question? So we're going to take that out, and we do all of our billing in flat fees, and these are all agreed to in advance. We're very upfront, and you will know exactly what your charges are going to be beforehand, because to me that's so important. I talk a lot. I don't want you to think that you're going to be charged for the fact that I talk a lot. That doesn't make sense. So everything's flat fee. We have different packages. We make sure that everything, the correct package is chosen for you and your family, and we help guide you to that decision. But the number one thing that we really want to do is help guide you. We want you to make the decision. We want to educate you so that you're in that position to make an informed decision. That is so important to us. So the traditional experience, knee-jerk response to problems. You know, we want to plan ahead to avoid problems. We want to do all of this in advance to make sure that there are no knee-jerk responses. You know, a lot of attorneys treat their clients as just transactions or one-off transactions. And we want to be a little more relationship based. I want to learn about your family. I want to learn exactly what you need. I want to know if there's somebody in your family that you need to protect against, or maybe you have special needs beneficiaries in your family, and we maybe need to, take that into consideration. Or maybe you have somebody who's not very great at spending money and you want to protect against that. So I really want to get to know your family and work on a more relationship-based platform. Finally, one size fits all documents. These are going to be plans that are created specifically for you. This isn't a fill in the blank will. This isn't something that I just sit there and type in your name and your beneficiaries and it spits out in 5 minutes. This is a plan that's going to fit exactly what you want most, what is important to you, what is most important for your family, and how to protect your family the most comprehensively. So this, to me, that's so important. Again, that's kind of what I was experiencing with my son when I was looking at estate plans was, is this really going to protect him? So our plans will be created specifically for you and your family and what they need the most. So my promise is that if you plan with us, your estate plan will leave no stone unturned and will give you the peace of mind knowing that your loved ones and assets are kept out of court and conflict. And this is my promise to all of my clients. It's personalized, it will be tailored, it will not be a fill in the blank will. It will absolutely think of all of those future things that could happen and make sure that you are protected and your family is protected and that you can have that peace of mind. So our process is a little different than the regular attorney, as you've probably guessed. Our process is typically about an 8-week process. We begin with a family wealth planning session. And this is when we sit down with you, your spouse, if you have one, and we really talk about what your current situation is and how we can best draft a plan for that. We help educate you to understand what would happen with no plan with your family situation and what would happen with a personalized and tailored plan. If at that point you decide to move forward, the family wealth planning session is designed to be an educational session. It's purely educational. You're under no obligation to hire me at this point. It's just a place where we can really help educate you even further than this webinar is. And if you decide at that point to go forward, to purchase one of our plans, to go ahead and protect your family, keep them out of court and conflict, move forward with something that you've been probably pushing to the back burner for a long time, we will go ahead and do that. And we'll do a quick design session, typically right after the family wealth planning session, but it could be later if you need more time. And we go ahead and design what your plan's going to look like. From that point forward, we go ahead and schedule a signing ceremony 4 weeks out. This is going to be the meeting where we sign all the documents. We notarize all the documents. We witness them. At this point, they will become effective. And so this is 4 weeks out. That gives us the time that we need to make sure that all of your documents are drafted exactly how you want them. We send you confirmations to make sure that all of the information is correct. If you had to, the need to think of anything beforehand, you can go ahead and we'll get that information from you in a secured way in between these 2 meetings. So the signing ceremony, we give you, we have all the documents ready. We go ahead and sign them. We notarize them. We get them ready. But you don't walk away with them quite yet. They are in effect at that point. You are safe, your family is protected, but you're not going to have them quite yet. We take them back, we scan them in. This way we can provide y'all with a USB drive of your documents. This is kind of an extra protection. You'll have your originals, and we always tell you to put that in a very conspicuous spot on a shelf. But also we want you to have an electronic copy as well that you can put into a safe deposit box or a fireproof lock. And then also we keep copies of the signed documents in our secure folder in case anything was to happen and they were needed. So we keep all of those files for our clients as well. And during this final meeting, we deliver the binder to you. This is when we actually hand over this binder. We hand over your USB drive. We also really encourage our clients to do a life and legacy interview. And this is something that, again, goes far and above what the typical attorney will offer. This is where you get to share your values with your family and your experiences and your story and help them understand why you're doing this, where you came from, why things are important to you. And it's so important, and it really, it's kind of fun because you get to kind of look back at your life and see why you've turned out the way you are. And you get to share that with your kids. And hey, on the plus side, if nothing happens and you live to be the ripe age of 90 or 100, you can watch this video later with your kids and just see where you were at this place in time. You know, maybe your kids are 1 and 3. You get to kind of go back and experience what you're feeling at that moment, and it can be kind of fun to watch with your kids and your family. And so to me, this is a very important part of estate planning. It's beyond leaving just your assets and protecting your children. It's also leaving your values. So this is when we would do that as well. So that final binder delivery meeting, we would also do the life and legacy interview if our clients wanted to. Again, it's optional. It's not required. Our average fees are going to range between $2,000 to $5,000. Again, all fees were very transparent. They're all agreed to up front. You will know exactly what your options are when you get to make the decision of what your plan is going to look like. So again, the whole process takes about 8 weeks from start to finish. And then after that, we actually offer a complimentary 3-year review with all of our clients as well to make sure that there aren't any changes that need to be made. So I mentioned at the beginning that we're going to be offering a free gift to y'all if you hung with me through this whole webinar. So here it is. So we would like to offer y'all what we call the $1,000 golden ticket. And this is going to be a complimentary family wealth planning session. This is normally a $750 charge. This is that meeting, that first meeting that I was telling you about, where we kind of sit down with you and we educate you on where your family is. We learn more about your family and how your family could be better protected. It's purely educational. Again, this is a no obligation meeting. You're not obligated to hire us afterwards. If you do choose to move forward with us after this family wealth planning session, you will get a $250 discount on your estate plan. No matter what you choose, whatever plan you decide best fits your family, you will get a $250 discount. Again, we're so thankful that you took the time out of your day to hang with us with this webinar, and we're very excited to work with you and get to know your family. So how to move forward at this point. So if y'all will look at the chat box, we'll go ahead and give you the link to our scheduling app. You can schedule either a family wealth planning session directly online, or you can either schedule also a 15-minute consultation if you just want to talk to me to learn a little bit more first before you sign up for this family wealth planning session. Either way, you can schedule online. We'll put both of those links up in the chat box right now. You can also email me if you have any questions. Please feel free to reach out. Again, our main goal is just educating the Athens and Georgia community on estate planning. So we're happy to answer questions and help you in any way possible. So please, please, please stop pushing this to the back burner. Use this gift as the motivation you need to go ahead and jumpstart your estate planning for your family, protect your family, put them in a better place, and make sure that if anything is to happen to you, they're always protected, and they know how much you love them and went above and beyond to give them this huge gift. So please, again, don't hesitate to contact us if you have any questions, or you can go directly online and go ahead and schedule your family wealth planning session today. That $750 value is going to be given to y'all for free. So please jump in. And then also there will be a code in the chat box that will tell you the promo code to enter to get that family wealth planning session for free as well if you schedule online. You can also call me to schedule as well. So thank you again for hanging in there. If you've asked any questions in the chat box, I will absolutely be getting back to you with those answers. Again, thank you. So thankful that you took the time out of your day, and let's get this ball rolling and get y'all that peace of mind knowing that your family and friends are protected at all times. Thank y'all so much, and I hope you all have a wonderful day.